Call this meeting of the Committee on Public Safety, Finance, and Policy to order. We do have a quorum present. Before we get to our agenda, I'm going to read the standard statement. Everyone here today must be seated when they're in the hearing room. There will be no standing or sitting on the walkways or aisles. If you need further accommodation, please communicate with the sergeant's staff. Signs are not permitted in the hearing room or at the table. Please leave all signs outside. Clapping and other disruptions are not allowed. All of the testifiers who have signed up in advance have been provided with a time limit for testimony. Please adhere to these limits or we may have to cut you off. The time limits are provided so we can keep the meeting on time and hear from as many people as possible. And thank you to our sergeant's office staff who are present for helping maintain decorum in the committee hearing room. We have 6 bills on the agenda today, and thank you to everybody who submitted letters and written testimony. Committee materials are posted online, and we do have copies in the front for the public, and they are in the member packets as well. The first order of business is approval of last meeting's minutes. Representative Berg may have a motion to approve the minutes for February 25th, 2026.
So moved, Madam Chair.
Representative Berg moves approval of the minutes for February 25th, 2026. Any discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Aye. Opposed? The motion prevails and the minutes for February 25th, 2026 are approved. The first bill on the agenda today is Representative Curran's bill, House File 3768. I see that you are already at the table with your testifier. Well done. Representative Curran, would you like to move House File 3768 be recommended to be placed on the general register?
Yes, Chair, that is my motion.
All right, and I do see that you have the A1 amendment to get the bill in the shape that you would like. Any discussion that you have, any comment you have on the A1?
I would just offer that the A1 amendment updates the statute to accurately reflect DOC's current substance use disorder practices. So
All right.
that's essentially what it does.
And are you moving the A1 amendment?
I would like to move the A1.
Very well. Any discussion to the A1? Seeing none, all those in favor signify by saying aye. Aye. Opposed? The A1 amendment is adopted. So please tell us about your bill as amended.
Thank you so much, Chair and committee members. I'll be brief. We've got some recommendations for updates from the Department of Corrections today, and I'll kick it over to them to explain. Thank you.
All right. Welcome back, Commissioner Schnell. Please introduce yourself and explain the bill to us.
Thank you so much. Good afternoon, Chair Moeller, Representative Curran, and members of the committee. My name is Paul Schnell, and I am the Commissioner of the Department of Corrections. This bill makes a practical overdue update to Minnesota's licensing framework for juvenile placement facility and halfway houses. In 2021, on a bipartisan basis, the legislature passed the Hardell-Sherrill Act, which included the establishment of graduated licensing tools for the DOC to use with local adult correctional facilities. The legislatively authorized additional tools, including a continuum of options from corrective action plan requirements to conditional license orders, all focused on gaining compliance and progress monitoring versus a singular option of shutting the facility down through a licensing revocation action. The law also provides a clear appeal process, but these tools do not apply to the juvenile detention facilities or state licensed halfway houses. Instead, they remain stuck in the previous all-or-nothing system. The tools provided by the Hardell-Sherrill Act creates options to allow the facility to stay open while ensuring that deficiencies are swiftly addressed and monitored by licensing staff. The ability to access the expanded tools provided in the Hardell-Sherrill Act promotes stability for youth residents and facility staff while holding facilities accountable for the changes that are required and needed. I want to be clear. This bill does not change jail licensing. This bill simply extends the graduated model to all DOC licensed facility types, creating consistency across the system. This proposal also addresses a confusing structural issue in the statute. Currently, provisions in the law that pertain only to state-operated correctional facilities are embedded in Section 241.021, making it appear as though they apply to all facilities, which is not the fact. Case. In this situation has created confusion for those who rely on the statute for public policy guidance, including facility staff and leaders, state regulators, and members of the public. This bill resolves that by relocating the state prison-only sections into more appropriate and relevant sections of law, so it is easier to understand the distinctions. The Minnesota Juvenile Detention Association has been a strong and thoughtful partner in shaping this proposal, and I want to thank them for their meaningful engagement and support of this bill. Our goal is to create a licensing framework that is consistent and predictable. Thank you to Representative Curran for authoring this bill, and thank you, Chair and members, for your consideration. I'm happy to stand for any questions.
Thank you, Commissioner. And we have one other testifier signed up, and that is Director Matt Bauer from Dakota County Juvenile Services Center. Director Bauer is appearing virtually. So welcome to the committee, Director. Please unmute yourself, introduce yourself, and begin your testimony. We are unable to hear you.
Can you hear me now?
Oh, there we go. There you go.
All right.
Please introduce yourself again and begin.
All right, thank you, Chair Moeller, Representative Curran, and members of the committee. My name is Matt Bauer. I'm the Deputy Director overseeing the Dakota County Juvenile Services Center, and I'm here today representing the Minnesota Juvenile Detention Association, or MNJDA. MNJDA is an organization consisting of 13 facilities that provide secure detention and treatment services for youth across Minnesota. House File 3768 impacts MNJDA facilities directly, and we would like to thank the Commissioner of Corrections and his staff for involving MNJDA in the development of these proposed changes to the licensing of our facilities. This bill will allow the Department of Corrections to use conditional licenses, require corrective action, and monitor progress towards compliance rather than immediately shutting down. We at MNJDA believe we should be held to the highest standards of care for our work with the most vulnerable and high-risk youth. As we attempt to navigate the mental health boarding crisis in our facilities, we believe a strong and collaborative partnership with the Minnesota Department of Corrections and their licensing unit is needed and best supports safety and care standards for our facilities. This bill will allow our partnership to strengthen and for standards of safety and care to be met for all youth that we serve. MNJDA supports House File 3768. Thank you.
Thank you so much for your testimony. And we did not have any other members of the public sign up to testify, so we will move on to member discussion. Questions from members? Representative Steer.
Thank you, Chair Moeller, and thank you very much, Commissioner Schnell. Two questions for you. Will this result in any extra fees or costs to the counties? And the second question is, have you talked to the sheriffs and are they on board with this bill?
Commissioner Schnell.
Madam Chair, Representative, we, first and foremost, I think this is cost neutral. There is no cost to this bill. That said, there certainly can be things that come up during the inspection process that, if they're non-compliant with a standard, that could end up creating a cost. But that's certainly not the intent here, number one. And then number two, the sheriffs this has been shared with the sheriffs, but it is largely because it really affects those juvenile facilities, which are operated, generally speaking, by these independent bodies. They have not had, there's been no input obtained.
Representative Steer.
So no input, or you didn't talk to them?
Commissioner Schnell.
Madam Chair, Representative, we have shared the information with them and asked them if they had any input. We did not receive any.
And I'll just note too, we do get letters from them in opposition to certain things or in support of certain things, and we did not get a letter from them either way on this bill. Any further member discussion? Chair Navani.
Thank you, Chair Moeller. Thank you, Representative Curran, for bringing this forward. It's a good bill, and thank you for DOC for bringing it forward. I recommend a yes.
All right, Representative Curran, any closing comments?
I appreciate the yes vote. Let's do it.
All right, Representative Curran renews the motion to recommend that House File 3768 as amended be placed on the general register. All those in favor signify by saying aye. Aye. Opposed? The motion prevails. And I see you're both staying there, which is great, because next up is House File 3769. Also Representative Curran's bill. Would you like to move that House File 3769 be re-referred to the Health, Finance, and Policy Committee?
Thank you, Chair Moeller. Yes, that's my motion.
All right, and I don't see any amendments, so go ahead and tell us about your bill, please.
Thank you again, Chair and committee members. Like the prior bill, this bill provides further updates and clarity. This one more so broadly, as we see year after year, as sort of the technical updates bill. So with that, I'll turn it over to the commissioner.
All right, Commissioner Schnell, you know the drill.
Yes,
Please introduce yourself and begin.
Yes, Madam Chair, members of the committee, again, my name is Paul Schnell, Commissioner of Corrections. I'm here today to provide a closer overview of the provisions in House File 3769 and explain how they will support the work of the agency. One of the changes in this bill addresses a gap in the statute related to tuberculosis screening. Current law requires TB screening, but does not clearly outline a process when incarcerated individuals refuse testing. This bill clarifies both the medical standards and the legal pathway. It also updates the statute to reflect modern medically accepted TB testing methods. Next, the bill clarifies that there can be a mental health unit at more than one facility and allows for a short-term care, assessment, and evaluation and stabilization when clinically appropriate at the Oak Park Heights facility. This improves flexibility, ensuring individuals experiencing acute mental health needs can access the facility and appropriate care as needed. Lastly, the bill clarifies in statute that the department operates multiple levels of substance use disorder treatment, including residential, intensive outpatient, and outpatient programming for adults and juveniles in our custody. In closing, the changes in this bill are technical in nature, but they are important to ensuring that the Department of Corrections operates effectively and efficiently. And with that, I would say thank you again and stand for any questions you may have.
Thank you. We did not, again, have anybody from the public sign up to testify on this bill, so we'll move to member discussion. Any questions? Representative Steer.
Thank you. I have the same questions to this. Is there any cost shift to the counties, and are the sheriffs on board?
Commissioner Schnell.
Madam Chair, Representative, this really affects the Minnesota Department of Corrections facilities only, and this is cost neutral.
Anything else? Chair Novotny.
Thank you, Chair Moeller. Thank you, DOC. Thank you, our Commissioner Snell. Thank you, Representative Kern, for bringing this bill forward, and I recommend a yes vote.
All right, Representative Kern, any closing comments?
No, I just thank the chair and committee again. Yes is so nice. Let's do it twice.
All right, so Representative Kern renews the motion to re-refer House File 3769 to the Health, Finance, and Policy Committee. All those in favor signify by saying aye. Aye. Opposed, the motion prevails. We're going to do a shift here because I'm going to go to the testifier table, and Vice Chair Feist will take over.
Great. The next bill on today's agenda is House File 3405, Chair Moeller's bill. And Chair Moeller, would you like to recommend that House File 3405 be placed on the general register?
That is my motion.
Great, your bill is before us. We do have an author's amendment. Would you like to move the A3 amendment to get the bill in the shape that you would like to present it in?
Yes, so, Madam Chair.
Great, any discussion to this amendment?
Yeah, just so that members know what this amendment does, it does three different things. It broadens the definition of federal agents because the original bill inadvertently omitted some agencies. It makes the effective date retroactive, and it deletes the sexual assault investigation section, which is painful for me to delete, but by doing that, we eliminated the fiscal note, so the bill now does not have a fiscal cost.
Great, thank you so much for that explanation. Any member input on the amendment? Seeing none. Those in favor signify by saying aye. Aye. Those opposed? The amendment is adopted. I forget if I'm supposed to do that, but I'm going to do it. So amendment is adopted. Chair Moeller, please tell us about your bill as amendment.
Thank you, Madam Chair. Members, this bill ensures that the BCA investigate all law enforcement use of force cases resulting in death in Minnesota. The use of force unit at the BCA was created with bipartisan support after George Floyd's murder, and I think all of us on this committee can agree that the unit does outstanding work, and it's fair to both defendants and to victims. Currently, the statute requires only the BCA to investigate use of force cases involving death from peace officers, which by definition in our statute is limited to Minnesota peace officers. This bill closes the loophole and adds that they should be required to also investigate deaths caused by federal agents. Operation Metro Surge has resulted in the homicides of Renee Good and Alex Preddy at the hands of federal agents, and there is no cooperation with the state in these investigations. Those in charge of the investigation prejudged and tried to turn this on the victims and actually resulted in dozens of experienced attorneys resigning from the Department of Justice. This administration's handling of these cases, or lack of handling in this case, is contrary to international protocol on death investigations involving government officials. And you can read more about that in the letters in your packets. We did have some discussion on the floor about this bill, and based on some comments that were made, then I just want to emphasize a few things. First of all, this bill does not force the federal government to comply, nor does it interfere with a federal investigation. This bill is about the state investigating deaths of Minnesotans in Minnesota. Second, a question was raised, why put this in statute when the BCA can already conduct its own investigation? And there are two reasons for that. First of all, Superintendent Evans will not be forever in charge of the BCA, and we don't know what future superintendents will do, and we want to make sure that the state investigate deaths like Goods and Preddy's. Second, by putting this in statute, local jurisdictions where these deaths happen will know that the BCA will be coming to conduct an investigation, and that provides clarity in law that should be welcomed by everyone. This bill also does not disparage law enforcement. Minnesota's well-trained officers have worked hard to build good relationships with communities. Unfortunately, the actions of federal agents who have acted without regard to the Constitution or the laws, as federal courts have determined, are undermining the good work by our Minnesota law enforcement. This bill holds those federal agents to the same standards as Minnesota law enforcement when there is a death caused by use of force. And I have Deputy Superintendent Mueller is available for questions, but doesn't need to provide testimony, but is again available for questions. And hopefully you can support this bill. Thanks.
Thank you, Chair Moeller. We do have one member of the public who signed up to testify, Dr. Bibi Newman. You can make your way to the testifiers table now. And before you begin, please state your name and title for the record, and you may proceed. And just so you know, we have a 2-minute testifier limit today.
Thank you, Madam Chair, co-chairs, and members of the committee. Thank you for the opportunity to testify. My name is Dr. Bibi Newman, and I'm a St. Anthony Village resident testifying as a private citizen. I'm speaking today in light of the amendments adopted to House File 3405. For the record, I submitted written testimony on February 24th and appreciate your consideration of those materials. House File 3405 proposes to require the Bureau of Criminal Apprehension's Use of Force Investigations Unit to conduct investigations of incidents involving federal agents within Minnesota. This bill expands the statutory definition of officer-involved death to include deaths resulting from the use of force by federal agents, including those employed by agencies such as the Department of Homeland Security and its components. Minnesota statute already reflects a legislative determination that independence in use of force investigations enhances legitimacy and public confidence. This is the structural principle this bill builds upon, extending Minnesota's independent model to a defined category of federal agents operating in our state. I want to be clear, House File 3405 does not attempt to regulate the operational authority of federal agents, nor does it impede lawful federal action. It simply defines Minnesota's own investigative process when a death occurs here, preserving the state's traditional authority under its police powers to conduct and structure its investigations. This is distinct from controlling federal conduct and does not conflict with the Supremacy Clause. House File 3405 respects federal prerogatives while ensuring Minnesota's investigative framework is impartial and consistent. Moreover, extending Minnesota's independent investigation standards supports both procedural integrity and public confidence. These are principles recognized in domestic practices and international frameworks for death investigations. Clarifying cooperation mechanisms and access to evidence would further strengthen the bill, ensuring investigations are not only independent in name, but effective in practice. For these structural reasons and in recognition of the importance of impartial investigations regardless of agency affiliation, I respectfully urge your support of House File 3405. Thank you for your time.
Thank you so much, Dr. Newman. And with that, we will move to member discussion. I don't have anyone on the list thus far. Does anyone have anything that they would like to say? I'm seeing no comments, so I will throw it back to, oh, sorry, I'm so
was just
sorry. Chair Novotny.
Thank you. Are we on the main bill or
We are on the bill as amended.
as amended? I don't know what your title is now, but Scott, could you come to the table?
I have deputy superintendent, but is that correct? It is. Okay, good.
Okay, please introduce yourself.
Good afternoon, Madam Chair, Committee. My name is Scott Mueller. I'm the Deputy Superintendent with the Bureau of Criminal Apprehension.
Great, thank you so much. Chair Novotny.
Deputy Mueller, are you conducting investigations on the named incidents?
I'm sorry?
Are you conducting investigations on the investigations using use of force, deadly force?
Yes, we are.
So you are conducting investigations. Since the use of force unit has been set up, remind me when that was, and then how many federal officers or federal employees have been investigated in that time?
Deputy Superintendent.
Thank you. Madam Chair and Committee, Representative, the Force Investigative Unit was set up in
Can you get a little
mid-2020.
closer to the mic? Thank you.
The Force Investigative Unit was set up in mid-2020. We have, on average, about 16 to 24 use of deadly force cases every year in Minnesota for about the last 40 years, outside of 2 years that were slightly higher than that. So you can extrapolate the number of cases that this unit has investigated related to use of deadly force since 2020. As it relates to federal investigations, we include both task force officers that are acting in the capacity of a federal task force, along with also federal agents. And it's been somewhere in the ballpark of 6 to 8 over the last 8 years.
Chair Novotny.
Thank you. Members, as we just said, Co-Chair Moeller has indicated that this would not force the feds to do anything. The Deputy Superintendent Mueller just testified that there are investigations being conducted. He has investigated not only these, but other federal officers in the past. I don't believe this bill is necessary, and I recommend a no vote.
Chair Mueller, would you like to respond?
I can wait till my final comments.
Okay, great, thank you. I had a comment. Deputy Superintendent, you saved the life of my friend when you intervened, and the ICE officers had surrounded my friend's car and were banging on his windows with their guns. And my friend believes that you de-escalated the situation and saved his life. And I just wanted to publicly thank you so much for the work you do.
I appreciate your comments. Thank you.
Thank you. Oh, we do have actually Representative Pinto had a.
Yeah, thank you, Madam Chair. I actually have a question. I want to be a little bit, I'm actually curious about this. When I'm looking at this underlying law, I mean, before the unit was created, incidents involving use of force by law enforcement were investigated. It's just they were investigated by local law enforcement. And what this did is that required that those investigations be done by your unit as opposed to local law enforcement. Is that correct? Maybe we'll first clarify that.
Deputy Superintendent, I can't see you, but I see you're still there.
Madam Chair, Representative, that is correct. However, we would do approximately 95% of use of deadly force investigations for decades.
Okay, thank you, Madam Chair.
Rep-
Yeah, so, but now I guess under the law, it's 100%. We want to make sure, for all the reasons that this was established with bipartisan support, to have a standardization and have it done effectively and all that. So what this bill does then I mean, so if a crime's committed in the state, law enforcement investigates the crime. This provides that there is the standardization, all the support that the BCA use of force unit has to investigate. I'm confused by Chair Novotny's position that because the unit is doing so, that it wouldn't be necessary. I mean, for one thing, I would think that you'd want to make sure, the same arguments as happened in 2020, that there is in fact a state-level investigation by the BCA rather than, let's say, by a particular local law enforcement unit, for the same reason we want to do that for state-level law enforcement use of force incidents. Members, we need to be careful in all sorts of areas to say that, well, something is going to be a problem, but then it turns out it's not needed. Like, the fact is that there were incredible apparent violations of rights. They should be investigated. We thought in 2020 that the way to get that done was to have a state-level dedicated unit to do so. As far as I can tell, done so with dedication and expertise. Why we would not want to have that happen with respect to federal agents does not make any sense to me, because a reminder that what happens is then instead they're going to be investigated by local law enforcement, apparently to the extent that they even can. But to say that because it's already happening, we wouldn't want to have our law be consistent with that. We apparently have no problem with it happening. I didn't hear any concerns there. So why would we not want to have the statutes reflect what in fact we all say should be happening for the protection of everybody involved? So I certainly argue in favor of this. And Madam Chair, I would request a roll call.
Thank you. Representative Curran?
Thank you, Chair. Thank you, Chair Moeller, for your bill. And I know you mentioned we had some discussion of this on the floor, and the points brought up there and today. I just want to ask for some clarification, because there seems to be an understanding or some kind of representation that the BCA is doing the investigations on the specific murders of Renee Good and Alex Preddy. And so I wanted to clarify that when, and this question is for the Deputy Superintendent, when the BCA, on the day of, let's say, Alex Preddy's shooting, when they attempted to gain access to the scene immediately, as it was out in public, and we know evidence can be easily destroyed by all kinds of things, my understanding is that the BCA was there to try to conduct an investigation and collect evidence. Could you clarify for us if the BCA was able to do that?
Deputy Superintendent?
Madam Chair, Representative, the BCA was there. We had legal process to be there and process the crime scene. We were not allowed into the crime scene.
Representative Curran, follow-up?
Thank you, Chair. I appreciate that answer, and I'm sorry, I'm disappointed by that has to be your answer. And I think in the context of this conversation, it's quite misleading to say that the BCA is conducting an investigation on this. When we think about our, sort of highest, one of our most qualified departments in the state, we assume that an investigation means that they have had access to everything that they need, reasonable access, at the time that they needed it, and that information would be shared between the agencies who are involved. It is my understanding that none of those things have happened, and that the BCA is relying on information that they were able to obtain even after arriving at the scene with a warrant to conduct their investigation, and were denied access even with a judicial warrant to be there, which they really didn't need to have anyway, but did because of the obstruction of federal government on the investigation. So I just want to make it very clear, we have heard from the BCA on the record that in fact, no, they have not been able to investigate incidents appropriately in the way that we would hope all incidents of this nature are investigated in the state of Minnesota.
Representative Duran?
Thank you, Madam Chair. Can I just have something clarified for me? Did you say that you actually investigate 100% of the officer-involved shootings, or is it by request from the actual departments themselves?
Deputy Superintendent?
Madam Chair, Representative, really both. We have it in law that we are mandated to investigate all use of deadly force that result in a death in the state of Minnesota. For our federal partners, we also get called by local jurisdictions where a death has occurred in their city. In the good case, that would be by the chief of police in Minneapolis.
Representative Duran, follow-up?
Yep. Thank you, Madam Chair. Would you say that there's, I guess, less cooperation between the federal government and state local law enforcement now, or before all this stuff came through, or is there a political part of this that's kind of hindering your guys' relationship right now to actually work with the federal agencies? Because what I'm seeing right now is that there was a long-standing relationship with the federal government, the state entities, to do actually combined investigations, which I've done multiple with federal agents before. It just looks like now we're kind of playing political games with the BCA, and I don't know if I like that, just because of the fact that now we're interjecting you guys into kind of a political tug-of-war right now. And with the current climate, it would have been better if we would have had cooperation from before with, I guess, maybe the governor, attorney general, maybe a county attorney that all want to push this. And, obviously local legislators are pushing this stuff. If we would have cooperation from, I guess, our local political influencers, would that have made it easier for you to do your job from the start?
I would like to throw this to Chair Moeller, if she had anything to say in response. It sounds like more of a political question.
Yeah, thank you, Madam Chair. Well, I think the fact of the matter is that they have worked together over the years, and until Operation Metro Surge came, it's really my understanding that that was the first kind of situation where there wasn't that level of cooperation that the federal agents or federal government had with the state level. And so when you say cooperation, I'm not quite sure what you mean about that, because I don't know that anything that any leader said is responsible for the deaths of Alex Preddy and Renee Good. But I think what this bill is trying to do is close a loophole that we noticed that we never really needed to look for before, because there always was this level of cooperation. And after this cooperation didn't exist anymore, it was evident that our law that we drafted in, after George Floyd was killed didn't cover federal agents. And again, we're not forcing federal agents to comply with this new law. This wouldn't require that. But what it would do is make it very clear, to Chair Pinto's point, that when one of these situations happens in somebody's district, they know that the BCA's use of force unit and the good work they do are going to come in and investigate, regardless of what the federal government decides to do. Would we like them to have cooperation investigating a crime together? Absolutely. But if that's not going to happen, we at least need to make it very clear in law that if someone is murdered or killed at the hands of a federal or local law enforcement, that this unit is going to do that investigation.
Thank you. And one more follow-up. We have a few more people on the list. Representative Duran.
Thank you, Madam Chair. I go back to the reasons why I jumped into the legislation before is because, there was a time where, not too long ago, that there was a huge defund the police movement in the state of Minnesota to actually separate and kind of create a divide within the general public and the police themselves. And then we continued on this separation even on the federal level. And I think it's up to us as legislators to calm down that rhetoric, to work with these local law enforcement and our federal partners in order to keep our whole community safe here. That is one of the biggest things that we need to do, is we need to put our political differences aside sometimes when we're looking at the general safety for everybody, to make sure that we're making the right decisions. We're not going out there saying ICE out or Gestapos or anything else, because that's only ramping up the rhetoric along with with the general public. Those are coming from us. That's coming from legislators. And we're going down the wrong path if we think that we're not playing ping pong with a BCA, because this is only going to cause a divide. And I'm sorry, I just can't support it.
Thank you, Representative Duran. It's so hard as when you're in the chair role because you're like, I have opinions, but I'm going to move to other people who are on the list. Representative Engen.
Thank you, Madam Chair. I just caught something earlier on. I just wanted to ask you a question about it, Chair Mueller. You said that Superintendent Evans wouldn't be there for forever. Could you expand upon that? I'm curious as to that statement.
Chair Mueller.
Yeah, thank you, Madam Chair, and thanks for the question. I wasn't hinting at anything, just to make sure. I'm just saying, by putting this in statute, we're recognizing no matter who the superintendent is, 10 years from now, 20 years from now, that we know that this unit is going to conduct those investigations, whether it's a local or federal agent that's involved in the use of force incident. So thank you for the opportunity to clarify. I'm not trying to start a rumor.
Cool. Any follow-up, Representative? Okay. Representative Berg.
Oh, thank you, Madam Chair. This question is for the Deputy Superintendent, and I'm sorry if you already made this clear, but is it unusual that when we see incidents as egregious as the Renee Good murder and the Alex Preddy murder, that the BCA is completely shut out of any of the pieces of the investigation?
Deputy Superintendent.
Madam Chair, Representative, this is the first time in my 17-plus years at the BCA that we've ever encountered this.
Representative Berg, follow-up.
Yes, thank you, Madam Chair. In that case, just thank you so much, Chair Moeller, for bringing this apparently critical bill forward. Appreciate it. Thank you.
Thank you. And I'll just chime in to say I think this is an important bill. I don't think it is, playing political hot potato. I think it's just ensuring that the BCA has the access and tools and authority to do its important work. So I support it as well. And with that, I will turn to Chair Novotny. You had some comments?
Deputy Superintendent Mueller, would this bill change what's going on with the two cases?
Deputy Superintendent?
Madam Chair, Representative, I guess I don't quite understand the question. Are you asking, with the change of this bill, will there be a change in investigation?
Would this force the federal government to cooperate with the BCA?
There's nothing in the bill that would force the federal government to do anything.
Thank you, and I'd just like to point out that Operation Metro Surge, from what my primitive internet search started December 4th, 2025, and depending on who you look to cite, Hennepin County and Minneapolis have been talking about being sanctuary states and blocking cooperation between the federal government and the local governments for 10 to 15 years.
Chair Mueller, any closing comments?
Yes, thank you. I do want to follow up on a couple of things. The defund the police movement that was mentioned, and many of us were here in 2020 when George Floyd was murdered, and you would never have heard any of us say that in committee. And in fact, we've done nothing but fund police over the years, including in 2023, the $300 million that was given to local jurisdictions to do what they wanted for public safety. So it's frustrating to hear that. I know other folks said that, but that wasn't said here, and it certainly was never part of the Democrat platform. And I think it's really important too to know the distinction between rhetoric and actually speaking out for people's rights and their constitutional rights. Calling out practices that violate the First, Second, Fourth, Fifth Amendments is not rhetoric. I mean, to us, and I think to many people that are speaking out, that's what being an American is about. That's what standing up for our principles and our democracy and our Constitution is about, and that's not rhetoric. So anyway, I just felt it was important for us to make that point and really do view this bill as closing a loophole that exists. It may not change the investigations, unfortunately, into Alex Preddy and Renee Good stuff, but it will say in any future cases, whether you're local law enforcement, state law enforcement, federal law enforcement, if a Minnesotan dies during a use of force incident, we have a unit that does incredible work, and they are going to come in and investigate that, whether we get the cooperation that we desire or not. And so for that reason, I think this is an easy vote, yes, for members. Thank you.
Thank you. For the discussion, members, Chair Moeller renews the motion to recommend that House File 3405, as amended, be placed on the general register. A roll call has been requested, and the clerk will take the roll.
Chair Moeller.
Aye.
Chair Moeller, aye. Chair Novotny.
No.
Chair Novotny, no. Vice Chair Feist.
Aye.
Vice Chair Feist, aye. Vice Chair Whitty.
No.
Vice Chair Whitty, no. Representative Berg.
Aye.
Representative Berg, aye. Representative Bliss.
No.
Representative Bliss, no. Representative Curran.
Aye.
Representative Curran, aye. Representative Duran.
No.
Representative Duran, no. Representative Engen.
No.
Representative Engen, no. Representative Greenman.
Aye.
Representative Greenman, aye. Representative Harder.
No.
Representative Harder, no. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hudson. Representative Johnson.
Aye.
Representative Johnson, aye. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Ream.
Ream, aye.
Representative Ream, aye. Representative Rapinski.
No.
Representative Rapinski, no. Representative Schwartz.
No.
Representative Schwartz, no. Representative Steer.
No.
Representative Steer, no. Representative Tapke.
Aye.
Representative Tapke, aye. Representative Hudson. There are 10 ayes and 9 nays.
I believe that based on the rules in a divided legislature, that this, okay. So there being 10 ayes and 9 nays, based on the way that the committee rules are structured in a evenly divided House, this bill does not pass out of committee. Do I gavel? Deputy Superintendent.
All right, the next bill for the calendar today is House File 3413. Representative Hollins' bill. Recommend that House File 3413 be placed on the general register.
Yes, Madam Chair, that is my recommendation.
All right, and I do see that you have the A2 amendment. First, would you like to move the A2 amendment?
Yes, Madam Chair, can I take a couple seconds to just explain it?
Yes, please, take your time.
Thank you. We have the A2 amendment, and I wanted to make sure that we brought this because we got some feedback from the Sheriff's Association about concerns that this would potentially impact other agreements that are between local law enforcement and federal agents. And we wanted to make sure that it was absolutely clear that this only impacted immigration enforcement agreements. We did have it reviewed by independent attorneys as well as our nonpartisan staff, who both said that they did not read the bill to be impacting anything other than immigration enforcement agreements. But just to be on the safe side, drafted this amendment that made sure there's comfort language.
All right, so Representative Hollins has moved the A2 amendment. Any discussion to the amendment? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed? The A2 amendment is adopted. All right, and we will take up, there are other amendments, but we'll take up those amendments after we move through discussion of the bill and testimony. So Representative Hollins, your bill as amended is before us. Please tell us about it.
Thank you, Madam Chair. Thank you, Chair Novotny. Thank you, members. 287G agreements have dramatically increased since Trump started his second term. There are currently more than 8 times as many 287G agreements across the country than there were at the end of the Biden presidency. 287G agreements, for those who don't know, deputize local law enforcement, like your city police or county sheriffs, to partner with federal agents and do their jobs for them in the realm of immigration enforcement. I personally have 3 main concerns with the 287G agreements that are in place and that may come in the future. First, it incentivizes racial profiling and unlawful detainment. This is both immoral and illegal. Pulling people over, stopping them, and detaining them because of the color of their skin, what their last name is, or their accents is explicitly unlawful. Because 287G agreements provide monetary bonuses for officers to detain more people, Law enforcement may be motivated by numbers and not about actually apprehending criminals as opposed to undocumented neighbors. Secondly, the illegal racial profiling leads to lawsuits. Many jurisdictions have been sued and have been forced to hand over millions of dollars, and those millions of dollars are generally paid by local taxpayers, so local residents. Instead of money going to schools or parks or road upkeep, Minnesotan tax dollars will go to paying lawsuit settlements that are caused because of these partnerships. And third, maybe most importantly, these agreements erode trust between public and local law enforcement. When local police are turned into immigration agents, communities stop seeing them as protectors, and instead they see them as deportation officers. This means that less crime gets reported, witnesses don't come forward when they see something illegal happen, and victims of domestic violence don't feel safe going to the police. All of this leads to less safe communities. We've talked a lot in this committee about not having law enforcement do things that they haven't been trained to do. We have noted that law enforcement aren't mental health professionals, they aren't social workers, and they're definitely not trained to interpret complex federal immigration statutes. I'll leave it there for now and turn it over to my testifiers.
All right, thank you. And I believe you have two testifiers. First is Noreen Shah, and then Hallie Pond. I see both coming to the table. And so I'm not sure who wants to go first, but whoever it is, just introduce yourself and begin your testimony. Welcome.
Thank you, Madam Chair. Representatives, my name is Noreen Shah, and I'm the Director of Immigration Policy for the National ACLU. I want to share with you 5 points today about this bill to limit local law enforcement from participating in the 287G program. The first is that we can disagree about immigration policy, but we can agree that ICE has lost public trust in recent months. And when local police enlist to work for ICE, which is what the 287G program is, that means local police lose that public trust as well. People don't want to call 911 if they think that ICE will show up at the doorstep. Abusers win when domestic violence and sex trafficking survivors are afraid to reach out and get the help that they need. The second thing, Minnesota law enforcement officers shouldn't have to follow the orders or be at the beck and call of federal officers when they are using face recognition apps to forcibly scan people's faces, when they're using excessive force, when they're racial profiling. We shouldn't put law enforcement officers of the state in that kind of confusing situation, a situation that can be a powder keg, that can be a recipe for legal violations. It's even more confusing when ICE is dangling a financial incentive, saying we're going to pay your salaries, we're going to offer you new phones and new cars, but you have to sign an agreement that says you will work at ICE's supervision and under ICE's direction. That is confusing for law enforcement officers who want to abide by the law, by state law, by their own police manuals. And that's not fair to put them in that situation. Third, if we talk about banning 287G, we're talking about creating statewide uniformity in the face of costly lawsuits that could cost municipalities millions and have in states and cities around the country. Local law enforcement might feel like they can rely on ICE's judgments about who to detain, who to hold. Unfortunately, we know that ICE's judgments in this regard are unreliable. Federal courts have found that with regard to detainers. And we know that people are being held unlawfully. Minnesota judges have found that. In fact, they found that ICE has violated more than 100 court orders requiring release. So we need that statewide uniformity so that law enforcement agencies don't feel like they are under pressure from ICE to join this program, to take ICE's word for it. Fourth, this bill, it's really important to remember, doesn't prevent ICE from operating in this state. It doesn't prevent ICE from knowing who's in local custody or knowing their release date. In that sense, it's a modest bill. Minnesota state law already requires that state officers immediately notify U.S. immigration officers when a detainee who appears to be a non-citizen is convicted of a felony or is, quote, mentally ill. In addition to that state law, it's common practice and has been for years that every time a person is booked into local custody, their fingerprints are sent to the FBI, which shares those fingerprints with DHS, which means DHS is notified of every person who is in local custody. And DHS has the ability, nothing is stopping ICE from having the ability and actually coming in and picking people up from a local facility. The last point is that by enacting this bill, you would be joining good company. Maryland and New Mexico just passed a similar bill in this legislative session Delaware and Maine passed these bills in 2025. Oregon, Washington, California already have bills that go beyond this. New Jersey has the same prohibition via Attorney General directive. That's 8 states. And with that, I'll pass it back to you, Madam Chair.
Thank you. And the next testifier, please introduce yourself and begin.
Yes, absolutely. Thank you, Madam Chair, and hello, fellow Minnesotans. My name is Hallie Pond. I'm a resident of Pine River, Minnesota, which is in Cass County. It's about 1,000 people big. And I'm the founder of True Space Consulting, which is a conflict resiliency practice. But today, I'm here as a neighbor, as a volunteer in the community, and as a believer in our shared constitutional rights. I'm here to ask you all to please vote yes on HF 3413. The 287G program erodes trust, it amplifies racial profiling, and it puts local communities at risk without our consent. Just weeks ago in Brainerd, federal ICE agents and local deputies entered a restaurant with 2 warrants and left with 4 people. That restaurant that was beloved, called El Potro, is now closed. The people taken worked here, they paid rent here, and they raised their kids here. They believed in the same American promise that we all share, that hard work, a commitment to a better, brighter future for our families and our children and their grandchildren, that this commitment will lead to opportunity and growth. When local sheriffs formalize agreements with ICE, they don't just assist federal enforcement, they become it. They stop people based on how they look, where they were born, or perhaps the sound of their name. That's not public safety, that's unconstitutional. And it makes all of us less safe. Because when people fear law enforcement, especially in small towns like mine, they stop calling 911. They stop reporting crimes. They stop showing up in our community. So make no mistake, these agreements don't just endanger public trust, they expose our counties to serious legal and financial risks. When counties formalize ICE partnerships through 287G, they risk holding people without probable cause. And when that happens, we've seen that counties get sued. And those lawsuits aren't just hypothetical. Counties in Arizona, Alabama, New York, Tennessee, and right here in Minnesota in Nobles County have been sued for millions of dollars. Those dollars come from local taxes, our tax dollars, which takes away from local schools, roads, and emergency services that are already severely lacking. And in Crow Wing County, we're not just talking about 287G agreements, we're talking about the intergovernmental service agreements to detain people for ICE, turning our local jail into a deportation pipeline, using local resources, local staff that are already understaffed, and local beds to advance a federal agenda. That's not accountability, that's mission creep, with no public oversight. Everyday people like an Apple Valley mother of 3 have been detained in the Crow Wing County Jail for weeks without cause, separated from their children, only to be released by a federal judge for being wrongfully detained. That's an exorbitant loss of resources. This isn't justice, it's cruelty. HF 3413 draws a clear line. Our sheriffs should protect public safety, not enforce federal immigration policy. It ends these dangerous, costly, and optional agreements, which aren't required to collaborate with ICE. It protects due process, it protects families, and it protects democracy. So I stand with neighbors in Cass and Crow Wing counties and many others across this great state that we all are so lucky to call home. And I request you to please, please vote yes on HF 3413. Thank you.
Thank you for your testimony, and we will ask you to move off the table for a minute, but stay in the room, please, because we do have 3 members of the public who signed up to testify. First is Bruce Messelet, if you want to make your way to the table, and then Dr. Newman also signed up for this as well, so please make your way to the table. And Sherburne County Administrator Messelet, welcome to the committee. Please introduce yourself and begin your testimony.
Thank you, Madam Chair, members of the committee. My name is Bruce Messelt, and I serve as the administrator for Sherburne County. I'm here to testify on behalf of the Sherburne County Board of Commissioners as well as our sheriff and law enforcement agencies. I would note that Sherburne County is not here to testify per se in favor or in opposition to the policy issues being discussed, but to point out the concerns and the practical implications we feel this legislation will have on several of Minnesota local units of government. In particular, I just want to highlight a few key points for the committee. First of all, House File 3413, as it reads and was introduced, is overly broad and would cast a very wide net on all law enforcement agreements with all federal agencies, not just relating to immigration. Now, I appreciate the amendment, but it doesn't go far enough. The 287G agreements, of which Sherburne County does not have one, falls under Section 1357. However, the bill also includes all, as was just noted, intergovernmental service agreements, which means anything that would touch any immigration issue would make those law enforcement agreements void under this bill. That is exceptionally problematic. Why is that? Well, we'll talk about Sherburne County. Since the 1990s, we have been providing high-quality public safety detention housing services for state, federal, other county, other states, and other counties in other states as part of our law enforcement functions. We do this in a highly professional, apolitical, and nonpartisan manner. This has been across multiple federal administrations, multiple Congresses, multiple state governors, and multiple state legislatures. We have done this service with changes in U.S. enforcement efforts and various immigration policies, interpretations, and practices. This is also done in collaboration with Minnesota governors, departments of corrections, commissioners, and the legislative bodies. We provide these services for such agencies as the United States Marshal Service, the Bureau of Indian Affairs, Immigration and Naturalization Services and U.S. Customs, now called ICE, the Federal Bureau of Investigations, the state of Minnesota, and other counties, as well as other states. Third, we have invested decades of operating and capital resources and training and personnel to develop what is truly a best-in-class facility. What do I mean by that? In 2022, the Sherburne County Sheriff's Office achieved the prestigious Triple Crown status from the National Sheriff's Association. This was established and has been awarded to fewer than 100 law enforcement agencies nationwide, or less than 3% of those agencies. The designation signifies simultaneous accreditation in three key areas: law enforcement and dispatch services, jail operations, and medical care within those facilities. That's an amazing thing for the facility in Minnesota to be Triple Crown accredited. Fourth, while we ideally would all agree that we don't necessarily want or feel that we should need the services of county jails or indeed any law enforcement in our communities, we do have to face reality. And facilities like Sherburne Counties and the other Minnesota facilities that have these inter-service agreements provide the best option for both our local law enforcement agencies, our state partners, and our federal partners when we have to deal with those who are detained or incarcerated. In fact, Sherburne County is the only accredited facility in Minnesota to assist with the United States Marshal Service. And sadly, we help detain some of the most dangerous and alleged violent criminals in Minnesota and the nation. We do this as their alleged crimes are investigated and the cases are prosecuted and their sentences are adjudicated. A loss of such facility would have a major impact.
Yeah, excuse me. Yeah, we said 2 minutes and we're over 4, but I've
I'm so
allowed
sorry.
some. Yeah, if you could wrap it up, please.
I can
that would
wrap
be
it up,
great.
sure.
Thank you.
What we'd ask from the committee is this. We really need clarification as to the bill's implications if it's intended. If it's specific to 287G agreements, it should say so. If it's a broader net, then we need to deal with that impact. We also need to understand how the bill will impact the state as well as the counties, and look at the financial considerations the bill will have on these agencies. That's the type of things that I think this bill needs vetting before we see it go further. Thank you.
Thank you. Dr. Newman, welcome back. And because we're on a new bill, if you would please introduce yourself again and then begin your testimony on this bill. Thank you.
Sure. Chair Moeller, co-chairs, members of the committee, thank you for the opportunity to speak today. My name is Dr. Bibi Newman, and I'm speaking on behalf of the St. Anthony New Brighton Welcoming All Families Association, which is an immigrant-led interfaith civic organization engaged in local governance and community transparency in St. Anthony Village. We have submitted written testimony for the record, and I will summarize our position briefly. We support House File 3413. The bill draws an important structural line. It ensures that Minnesota's state and local governments do not enter formal agreements that authorize enforcement of federal civil immigration law, including agreements under 8 U.S.C. Section 1103 and Section 1357G. Federal immigration law remains supreme, but under long-standing constitutional principles, states are not required to administer federal civil regulatory programs. Minnesota may respect federal authority while declining formal deputization agreements. In our community, there is significant concern among families affected by federal immigration enforcement activity. When local departments state that they do not interfere in federal operations, residents often struggle to understand where local authority ends and federal authority begins. That uncertainty creates confusion, particularly in municipalities like ours that span multiple counties and transport detainees across jurisdictional lines. House File 3413 does not regulate federal enforcement itself, but it provides clarity. It ensures that local governments are not formally embedded in federal civil immigration enforcement structures. Public safety depends on trust, and that trust depends on clearly defined institutional boundaries. For many families in our community, the bill represents an important safeguard, one that reinforces constitutional structure while preserving confidence in local public safety institutions. We respectfully urge your support. Thank you.
Thanks for your testimony. And next up, we have Sheriff Eric Tullison. Please make your way to the table. Welcome. Please introduce yourself for the record and begin.
Thank you, Chair Moeller, representatives. Eric Tullison. I serve as the elected sheriff of Kansas County, and I'm also here representing the Minnesota Sheriff's Association. I'm here today to offer testimony in opposition to House File 3413. At the center of this issue is not politics, it's not ideology, it's about local governance. Kansas County, like every county in Minnesota, operates under a county-administered public safety framework. The sheriff is elected by the people, along with the county board, and together, we are accountable directly to our communities for operational decisions involving our jail, our staff, and our public safety responsibilities. House File 3413 would prohibit counties, sheriffs, and local units of government from entering into immigration enforcement agreements with the federal government. It would also require the immediate termination of any existing agreements. That is a significant shift away from local decision-making. Under current law, counties already have discretion. If a county board or sheriff determine that an agreement is not appropriate for that community, they do not have to enter into one. That authority exists today. HF 3413 implements a statewide mandate that eliminates this discretion that I believe is essential to addressing public safety concerns at a local level. Counties differ, facilities differ, and community priorities differ. What may not be appropriate for one county may be manageable and operationally sound in another. A one-size-fits-all prohibition does not recognize those differences. In Kansas County, for example, we have over 25 years of experience operating under a federal detention agreement. We have built structured systems, trained staff, and established clear protocols during that time. My dedicated staff cares for roughly 100 detainees daily with compassion and dignity. Federal court appearances, religious observations, attorney meetings, recreational activities, mental health services, medical appointments, and dental care are all provided within the four walls of our jail. I think it's also important to understand that federal immigration enforcement is going to continue regardless if this bill passes. If local detention agreements were eliminated, individuals will not be released. They will simply be moved elsewhere, but potentially to distant facilities or out of state. When that happens, detainees with local ties, family members, support systems, and legal counsel may be separated from those connections. Again, my point is this: local public safety decisions should remain local. Thanks.
Thank you for your testimony, and we did not have anybody else sign up to testify. So before we move into bill discussion, we will talk about the amendments, and I believe there is an A1 amendment. Who will be moving that amendment? Chair Novotny to the A1.
Thank you, Chair Moeller. As Administrator testified and is saying, I know Sherburne County has spent considerable money over the years doing improvements that are ongoing, and they're planning on doing a much more extensive renovation, almost a replacement from what I understand, that'll be at considerable cost. So we need to know if there's some protection. My question to you, Representative Hollins, is maybe I'm wrong or didn't hear you right, but do you believe that your original bill would affect holding facilities, being able to hold and do, as Sherburne County does and several other counties do, that holds ICE detainees while they're waiting their disposition?
Representative Hollins.
Thank you for the question, Chair Novotny, and thank you, Chair, sorry. So I think that is a good question, and I was actually just texting with my testifiers about this because I want more information on this. I certainly would like to work with places like Sherburne County to ensure that they are able to continue holding people that are legitimate, but I do think that there's an aspect of it that is criminal. So criminal enforcement, which is different than immigration enforcement, right? And so the question is, are they being arrested? Is it a judicial warrant that's being used, or is it a criminal warrant that is bringing them in? And I think there's a real difference there, right? I don't know if my testifier has anything to add to that, or if nonpartisan research could address it.
Well, we'll move first to Ms. Schock because she came back to the table. So please.
Thank you. I do think that that's an important distinction in our colleague's testimony from Sherburne County that, there's U.S. Marshal Service detention of people who are charged with criminal offenses. This bill has to do with immigration enforcement, civil immigration enforcement, so it would be distinct from, as I read this bill, it would not affect the ability of a jurisdiction to hold people for those criminal charges through an intergovernmental agreement, which is just a completely distinct circumstance.
Chair Novotny.
Could nonpartisan check in on this?
Mr. Diebel.
Madam Chair and members, the bill generically refers to the agreement for enforcement of civil immigration law. I think that's not clear as to whether that includes the detention of someone pursuant to a civil immigration detainer.
Chair Novotny.
So we don't know. Well, in that case, I'll offer the amendment, and the amendment is just that if a government agency gets considerable cost due to the cancellation of the contracts, until we can get a little bit better resolution on what this bill means, I'll offer this and just ask for a yes vote.
All right, and before we do that, we have to get to the A3 amendment to the A1 amendment. Representative Hollins, are you offering the A3?
Yes, Madam Chair.
So please explain the A3 amendment.
Thank you, Madam Chair. Thank you, Chair Novotny. The A3 amendment would be saying that we would not be paying for the authorizing, or we would not be authorizing a reimbursement under subdivision 4 or 5 unless the federal government reimburses the state of Minnesota for the economic impact of Operation Metro Surge. I don't know how much people recognize or understand how devastated our communities in the Twin Cities were by Operation Metro Surge. Businesses were closed, people were laid off, they couldn't pay their rents, and not just immigrants, but like places where immigrants go to eat or shop. they had to cut their hours, and people were desperately impacted by it. There was one study that came out of that we got from northstarpolicy.org, and they say conservatively an estimated $106 million in lost wages just in Minneapolis. This has had a huge economic impact on the metro, and not just Minneapolis and St. Paul. So this amendment would be asking for a study to be done and compensation from the federal government for the devastating economic impacts that's had on the metro area before we would compensate the counties that have lost money from their 287G contracts being canceled.
Any discussion to the A3 amendment to the A1? Just to the A3. Chair Novotny.
We're discussing a bill on federal contacts. I believe that the amendment's a little out of the realm of the bill, and I recommend a no vote.
Any further discussion on the A3 amendment? All right. Seeing none, all those in favor of the A3 amendment signify by saying aye. Aye. Opposed? No. The amendment is not adopted. Now we will go to the A1 amendment. Discussion on the A1 amendment. Representative Hollins.
Thank you, Madam Chair. The A1 amendment, I understand the concerns that Chair Novotny has brought forward. I would still recommend a no vote, given that these are contracts that that counties have willingly gone into. This is part of the concern that we have with these contracts, is that they are depending on the income that's coming from the federal government, which is in fact not guaranteed any longer than this administration. And I think there's a real concern about taking federal funds to pay for salaries, bonuses, and equipment when that money is destined to go away and is predicated on bounty hunting our undocumented neighbors. So I would recommend a no vote.
All right. Any further discussion? Representative Greenman.
Thank you, Madam Chair. And I guess I just have sort of a question of how this would work, given what we have seen happen, and I think we'll get to the underlying piece of the bill about the liabilities that some of these agreements will take in terms of treatment. But one of the things that we know has happened since Operation Metro Surge is that citizens have been detained and released, and folks with legal status have been detained and released. I'm wondering how the compensation that that local jurisdictions are getting for immigrants that are undocumented, unlawful immigrant folks who are there under some color of law, if that differs at all, or if it's the same for the citizens and the folks who have been unlawfully detained, what the compensation looks like that the counties are getting.
So I'm not sure who your question is directed to.
It may be directed to the sheriff.
Oh, go ahead, Sheriff.
Chair Moeller, I'm not familiar with if the Candy Ojai Sheriff is housing.
Is what?
If he's housing anyone.
Oh.
If we're asking a question about housing costs, we might.
Go ahead, Sheriff. Answer that question first.
Thank you, Madam Chair. Yes, we do have a longstanding housing agreement. However, I'm not clear what the question is.
Go ahead, Representative Greenman.
Thank you. The compensation you're getting from the federal government for housing folks, is it dependent on whether they are citizens, whether they are charged? How is that differ? Does that differ based on the status of how they end up there and whether they're charged by the federal government?
Sheriff.
Madam Chair, Representatives, so the compensation is just based on a daily bed rate, just like we're a boarding facility, just like we would board for another county. It doesn't have anything to do with where they are in their immigration proceedings.
Representative Greenman.
Thank you, Madam Chair. Well, that is concerning because it feels like it could create an incentive structure to continue if you are paid, whether or not they are lawfully end up in your detention, and for as long as they're being detained, it feels like it could create reverse incentives. It also feels like it cuts against, and as we think about the compensation piece, when that happens, I think that the local jurisdictions take on real liability. And I think we'll hear more about that in the underlying bill. But both this amendment seems to actually accentuate the reason that this bill is so important, is that we don't want to create liability for our local jurisdictions to be detaining, unlawfully detaining, and part of violating the rights of citizens, and then potentially be on the hook for, when they do it, those taxpayers in those local jurisdictions. Thank you, Madam Chair.
Further discussion to the amendment? Any closing comments? Chair Novotny, you're shaking your head no.
Oh, yes.
All right. All those in favor of the A1 amendment signify by saying aye. Aye. Opposed? No. The A1 amendment is not adopted. Next, we'll move on to member discussion, and we do have a few members on the list so far. So Representative Curran.
Thank you, Chair. Thank you so much, Representative Hollins. Like a lot of ideas that I've seen, I see this as a really forward-thinking, smart proposal that you have in front of us. And I say that because the core of what this is getting at is local peace officers, local enforcement has worked so hard to get to know people and become trusted. And what I've seen in my community, even throughout Operation Metro Surge, regardless of where you land politically on that operation, what I've seen is that my local department's primary concern is with the increased federal activity is that their own residents locally will fear calling police because they're associating our police officers with federal agents, which in the general public is completely understandable. Law enforcement is law enforcement. You sort of have this general expectation of what law enforcement does and what they don't do and how they should treat you and how they shouldn't treat you. And whether or not, we read legal distinctions, whether or not we say, certain officers can act unconstitutionally and some can't, that conversation doesn't matter. What matters is on the ground in the relationships that people have and how they're treated throughout any sort of civil or law type cases. And I want to talk about the practical implications on local government that were mentioned. There's a lot of defense on what local government should be able to do, what local government should be able to enforce, what local government should be able to enter in a contract for. And look, local government's responsible to take care of their locals. Entering a federal contract immediately steps outside of what the purpose is, to care for your own, to care for your people. And so, I hear that there's a concern that if we don't allow for people to go to, certain facilities, that they're going to be sent somewhere else. Well, I have news for folks. If you're afraid that they're going to be separated from their families by going to a different facility, they were separated from their families when they got to yours. There's no difference there. And calling one facility that does such practices best in class, I'm going to be honest with you, in this committee, is a weird flex. That is a weird flex on this topic. Because what I'm hearing is, it's been done for a long time, or this bill doesn't do anything anyway. And you think you do it well, and you make money. Well, guess what? It doesn't make it helpful for public trust with local officers, and it doesn't make it right. I don't care how much money you make. I don't care that you think you do the wrong thing well. And I don't care if you think your detention facility that keeps people separated from their families deserves some kind of Yelp review in a committee. I don't have any questions. I just really, really appreciate your attention to this detail. And again, this is very forward thinking in maintaining trust with local officers who are funded locally, who are meant to protect our constituents. Thank you.
Representative Duran.
Thank you, Madam Chair. And Representative Hollins, do you trust your local law enforcement?
I do.
Representative Hollins.
sorry, Madam Chair. Yes, Representative Duran, I do. I've worked on developing a better relationship with them.
Representative Duran.
Do you think that maybe a little bit of cooperation would actually help actually keep your community safe if we have our local law enforcement that you trust actually influencing the other people coming into your community? Do you believe that that would actually change the way that we're looking at things? Because when you have local law enforcement that you trust actually coming into agreement with actually people that are not from your community to say, like, this is how our community is, so we can actually make some foundations to do this professionally, as safe as we possibly can. But not only that, to bring the community closer in regards to they have a job to do, we're gonna do it safely, and we're gonna do it by the support of our local law enforcement with the collaboration of everybody to make sure we're doing this safe. Do you feel that a collaboration would be better or worse? And obviously, it says that it's worse because, you know, you're just gonna have people operating that are not from your community, that are not from your area, that understand your community, that are just going in there and just doing whatever they want to do and then getting out, instead of actually teaming up with your local law enforcement that understands everybody inside there, that understands the complexity of the dynamics and the culture and everything else that are going on with inside some communities. So wouldn't you feel that that would be better?
Representative Hollins.
Thank you, Madam Chair. Thank you, Representative Duran. I'm really glad you asked this question because I wanted to take a second I'm looking at this side of the room and I'm like, there's so many police officers here. And you all are working in your community to build trust with the people that you represent, right? And you took time and you trained and you learned how to do these things and you like ramped up slowly to be able to represent your community and to know how to do your job. These federal agents did not. They got 42 days of training. Representative Duran, I bet you got more than 42 days of training, right? I bet you've been in your community, that you talk to people, that you know them and you recognize them. I bet you say good morning and you stop at the same bakery to get coffee when you have the chance, right? Like, you know your community. You trained for this job. I don't think any of you should compare yourself to these federal agents. Not Representative Whitty, not Representative Steer, not Chair Novotny, not you, Representative Duran, not you, not the sheriffs, not the police chiefs. You all work hard. You know the people in your community. You know how your community functions. Don't compare yourself to these federal agents because they don't know anything. They are not good at what they do. They are picking up people who are US citizens and detaining them. I don't want to see, y'all deserve better. And Lord knows, I have had my struggles with law enforcement. I have worked to repair those relationships with my police chief, with my sheriff, with the rank and file members that are in my neighborhood. It has not always been easy. But seeing this Operation Metro Surge has opened my eyes to how much better our local law enforcement is than these federal agents. They do not show respect. They do not show care. I'll tell you what, I do trust my local law enforcement because if I followed them in a car, they would pull over and they would say, is something wrong? Is there a problem? Do you need something? Are you in trouble? They wouldn't pepper spray me, they wouldn't tear gas me, they wouldn't try to break my window and yank me out of my car, right? Trust is a two-way street. I trust them because they have shown me respect. And I don't believe that these people who come in, who have extremely limited training, I mean, I saw an ICE agent wearing Keds one day, like those little white shoes that, like, you know, kids wear. They're not prepared for what they're doing. At a raid, she was wearing them. They're not prepared. They don't know what they're doing. They have not been trained well. And I think you all should not compare yourselves to them at all. And I don't think that there's anything that you can do to make them act better than what they're doing. And part of the reason is because they don't have the training and they don't have the discipline. And I think, I'm sorry, I'm trying to say this with love because I think you all deserve better than to compare yourselves to these federal agents.
Representative Duran.
I wouldn't necessarily say we're comparing ourselves, but what I'm trying to say is I'm trying to say that the people that you trust could influence the actions of the people that you don't. Okay? So if we're working hand in hand with people that you trust inside your community, that might actually kind of bleed off into the person that you maybe not trust. If there was a little bit more cooperation from the start, from all this stuff from the start, I guarantee you this would be a complete different picture. From the start, from the very start. If we had cooperation, this would be a completely different situation. You wouldn't have this problem. We wouldn't be talking about this. What we would have done is we would have slowed everything down. It'd be a little bit more targeted approach to what we're doing. Now it's like these guys are coming in, they're hitting it and leaving. They don't, they think they have who they got. But whenever you go out there, you're going to be protested by 20, 30 people like that because it's organized. So what I'm saying right now is that I think we as legislators need to take just a step back and kind of look at this as a whole and say a little bit more cooperation between everybody is going to do a lot better. We just had a bill that we heard that we want the BCA to cooperate the law enforcement or the federal government to get a better understanding for more transparency. And now we're having a bill that says, screw the federal government, we're not going to cooperate at all.
Oh.
So it's just it's strange to me how we're kind of battling right now, and we're putting police officers in the middle of this. And again, we're playing ping pong with law enforcement officers, the people that you trust to go out there and protect your community. It's going to be very hard to build these relationships that we need to move forward when we have legislation like this. We just need to take a step back, calm the nerves, and cooperate.
Can I respond?
Go ahead, Representative Hollins.
Thank you, Madam Chair. So, Representative Duran, what I'm hearing is that we should just comply with the federal government.
No.
Well, you're saying we need to calm down and just do what they say and cooperate. And that does not, maybe I'm taking it out of context, maybe I'm not understanding, but that doesn't seem, that doesn't seem like the message of the GOP, first of all. But second of all, that doesn't, I don't believe that it's gonna work that way. I really don't. I mean, your theory is theoretical, mine is theoretical as well, because we haven't seen either of these two things play out, right? There is still cooperation to some extent by law enforcement even in sanctuary cities, right? We know this. So for us to say that if everybody had just complied, that it would be better, I cannot believe is true. And what I know for sure is that people would stop, people in my city at the very least, would stop contacting their local law enforcement for everything else that they see. Everything else that they witness, everything that they hear, they would not want to talk to their local law enforcement if we were forced to comply. Because they're afraid. And I can't explain it to you any better than that. Like, I'm coming at this from my heart and not from my brain. I am talking to people on the streets, and they are telling me they are scared. So I made Representative Bliss laugh so much.
All right, we're gonna keep moving here. We've got several members on the list. Representative Ingen. I'm not on the list. Oh, you're not on the list? Okay. Representative Pinto.
Thank you, Madam Chair. I can't remember what I even had. I guess just a reminder, and this is going back to the last bill. We can influence what happens. I mean, maybe I'll there's a comment from Chair Novotny in response to the prior bill saying, look, there's nothing that we can do to influence the federal government. If that bill had passed, it wouldn't have affected the federal government in their actions. We can't force them to cooperate. And I guess I'd point out that that's not true in the sense that if our GOP colleagues were to call out the conduct of the federal government, were to say, federal government, we need you to cooperate. When a federal agent kills an American citizen, there needs to be investigation as to whether that is justified or not. We should all agree on that. And we, as Republican office holders, are going to call that out as much as our DFL colleagues, because we all have an interest in protecting rights. We all have an interest in following the Constitution. We can influence what happens. There's the statutes that are passed, and there's the actions that we take. Turning to this bill, we can influence the rhetoric that we use, the actions we take can influence. I'm certainly hearing that from my colleagues talking about the rhetoric that you're hearing. The rhetoric that you're hearing is us saying that our rights need to be protected, our Constitution needs to be followed, and everybody in our society has those rights. And that's what we're saying. We're calling for those rights to be respected, and it's just as simple as that. And it is not the case that there was some lack of cooperation initially. Everything that I'd heard was that before the surge, everything was working perfectly fine. Our different local governments were collaborating with the federal government to the extent provided by law. And what we saw is the federal government then comes in and takes the steps that you all have been hearing about for the last couple of weeks. And that, believe us, this is things that are from our neighbors experiencing this. Just people who are not interested in politics, just trying to go about their lives, live their lives, and stand up for their neighbors' rights as well. That is what's happening. And the alternative that we do here is that we just kind of roll over and just tell the federal government, sure, violate our rights. We won't do anything, won't look into it. We won't investigate it in any way. We're just going to kind of say, we hope that at some point you'll decide to stop investing in our rights. That is not acceptable, and that should not be acceptable to any of us looking back to our first principles as conservatives, as progressives. Should not be acceptable at all. What this bill is saying, look, we are going to take care of the safety of the people in our state and the rights of the people in our state. Federal government's going to do what it's going to do, and that's going to be fine. We're going to have that relationship. That has worked very well in our communities, and there's no reason that that should not be happening around the state, because the alternative has been really, really dangerous and violative of our rights. And to an extent, but remember, not only 2 people being killed, but a 3rd person being shot and having that situation be lied about under oath. Under oath. So even the 3rd person who got shot, unfortunately was not killed, it turns out, was a complete falsehood from the federal government and admitted to by the federal government. Representative Hollins, thank you for bringing this forward. And I really would encourage all of us to remember that we can influence what happens with the federal government, but the actions that we take. This is time for all of us on both sides to stand up. Thank you, Representative Hollins.
Representative Greenman.
Thank you, Madam Chair. And I sort of want to get back to this question of the cost of cooperation. And maybe this is a question for your testifier, Ms. Shaw. I think that there's been some maybe agreement, at least maybe not in this room, but broadly that there has been illegal, unconstitutional tactics that we've seen federal agents do. And because we have a bill on it, it's my understanding that that if that happens to you, you can't sue federal agents. I'm wondering what who's on the who's holding the bag for when that kind of behavior happens, and I'm wondering how that'll affect our local jurisdictions.
Ms. Shaw.
Thank you for the question, Representative. Local taxpayers are on the hook for these civil rights violations and the costly lawsuits, and that is clear from years and years of lawsuits and settlements. And just to name a few, in New York City, had to pay in a class action lawsuit $92.5 million. Los Angeles agreed to a $14 million settlement for conduct by its sheriff's department. These are for honoring ICE detainers. Smaller sums in New Mexico paying $350,000, San Juan County in that state, $190,000 San Francisco. I could go on and on. These are big numbers. This is in the context of illegal detention, holding people when you shouldn't have because they were citizens or they had status and they shouldn't have been held. Something more is happening here in Minnesota. Many, I believe it's 5 counties and police departments have recently signed on to a version of the program called the task force model. The task force model comes out of the jail and puts you into the street doing ICE's bidding. And when we're talking about ICE, that is operating using facial recognition technology to force people to submit their most intimate information. We're talking about racial profiling, excessive use of force. That potential for lawsuits is higher than we've ever seen for municipalities that work with ICE. We do know a little bit about what things could look like, though. Your state is new to the task force model of the program. There are other states that are less so. We published a report just a few days ago called Deputized for Disaster. In that report, we document about how this program is playing out in states around the country. One of the states is Florida, where you've got a number of counties, actually every county in the state is part of the 287G program. You'd think perhaps that by welcoming in ICE, that would mean that communities were safer because of that cooperation some of the other representatives were talking about. In fact, people are afraid to go to the grocery store, afraid to go down the highway, because through the task force model, ICE and Florida Highway Patrol and local law enforcement have set up checkpoints. You can't even go into the Florida Keys without entering an immigration checkpoint. Other states around the country where you cannot exit off of the highway without being put through an immigration checkpoint. People can't go to a concert without having their papers checked for their immigration status. That is what the task force model of this program brings to a state. It does not bring safety. It does not bring community trust. It brings more and more community fear, which means kids don't go to school, people don't go to the hospital. I don't have to tell you, you've been living that with regard to ICE and Border Patrol, and people around the country are increasingly living that with regard to their own law enforcement agencies that are sworn to protect and serve them. They're afraid of them, just as so many people here have been living in fear of ICE.
All right, just very briefly, because we have to move on. Representative Greenman.
Thank you, Madam Chair. And I think you make the case that when we talk about cooperation, we should be cooperating with the law, the Constitution, and our rights, and not federal agents who have shown that will throw those all out the window. And when we talk about being morally on the hook in Minnesota, and particularly if we allow these kinds of agreements, we're morally on the hook for the civil rights and constitutional violations, but it also sounds like taxpayers are on the hook for the brutal violations of federal agents. Neither of these things are acceptable in Minnesota. With that, Madam Chair, I'd like a roll call.
Okay, very well. Roll call's been requested, and I'll just make a quick comment as well based on the letters in our packet. I was very disappointed to see the Association of Minnesota Counties and the League of Minnesota Cities response to this, especially in light of the cost that were just described and the cost for Operation Metro Surge. I know that the cities, and I don't believe the county I represent, are reflected in this letter that we received from them. Vice Chair Feist.
Thank you, Madam Chair. I also had some comments about the League of Minnesota Cities letter, but to take a step back, statewide uniformity is important. We've had good conversations about like one size fits all does not always, it's not always the best approach, but I think it's particularly important on this issue. I was thinking about T and U visas, which are for victims of serious crimes and victims of trafficking. They were created in order to encourage immigrants who are victims to turn to their local and state law enforcement for help so that we could investigate crime and catch the perpetrators. And we need to know that victims aren't going to question whether or not they can reach out for help if they happen to be in Sherburne County or Crow Wing County or Hennepin County. You know, they're not going to be like up on the latest 287G agreements. So I do think that this is one of those scenarios where a statewide approach is actually really important. I also wanted to kind of highlight how 287G agreements work. Like, we're asking law enforcement who are not trained in immigration to then help enforce immigration law. And I wanted to briefly just share a story. Arizona had a state law that was like the show your papers law. And at that time, I was working with a client who was a physician. She was here legally, but she was in this 30-day grace period at the end of her status, and she was like transitioning to a residency, and so she had a pending change of status, but it wasn't approved, and so like, and she had an expired visa. So like, if you looked at all of her documents, like you would be like, ooh, she must not be here legally. And she was like moving to like Maricopa County, and I was like, ooh. And at the same time, I had a client who was a white Canadian dude who was totally here without status. And he and I were talking, and he's like, I could go to Arizona, I'd be fine, wouldn't I? And I'm like, yeah, probably would be. So like, immigration law is incredibly complicated. You know, a visa does not prove status, and you know, it's just like super complicated. So we want law enforcement who are experts in protecting victims and investigating and solving crime. We want them to focus on the things that they are skilled and trained to do, And in theory, we should have immigration officers who are skilled and trained in what they do. That doesn't always seem to be the case, but that division is actually really important. And I did want to comment on the League of Minnesota Cities letter because they use the exact same language in the final paragraph as they did when they opposed a bill that was kind of the opposite of this bill. And I just wanted to read from their letter and a couple of other letters submitted by trusted stakeholders on this and other legislation that's related. The League of Minnesota Cities wrote, "Local law enforcement agencies statewide depend upon trust-based relationships within immigrant communities to solve crimes and implement community policing strategies that promote public safety." That sure sounds like a good argument for this bill. I also wanted to cite to a letter that the County Attorneys Association wrote on a different bill, related topic. They wrote, "Local participation in federal immigration enforcement undermines public safety by deterring members of immigrant communities from reporting crimes and participating in the prosecution of those crimes due to their fear of immigration consequences." And lastly, I just wanted to cite to the International Association of Chiefs of Police, when they have been asked to weigh in on legislation like this or the opposite of this, they have said, quote, "State and local law enforcement should not be involved in the enforcement of civil immigration laws, since such involvement would likely have a chilling effect on both legal and illegal aliens reporting criminal activity or assisting police in criminal investigations." And so, I think that those are some trusted messengers, and I think we should listen to them, and I think we should pass this bill. Thank you.
Chair Novotny.
Thank you, Chair. I'll be very quick. I will actually limit my questions and statements to the bill at hand. Commissioner Snell, if you wouldn't mind stepping up to the testifying table quick. Commissioner Snell, I'll let you go through that.
Go ahead.
Commissioner Snell, state your name after I answer the question. How many incarcerated persons are in the DLC system right now that have immigration hold detainers on them?
Commissioner Schnell, and I'll just preface this by saying that you were not ever signed up for this particular bill, but if you can answer those questions, that would be great.
Madam Chair, Representative Chair Novotny, Paul Schnell, Commissioner of Corrections, there is approximately 380 people in DOC custody that are non-U.S. citizens. About 270 or so are subject to ICE detainers.
Thank you, Commissioner Snell.
Chair Novotny.
Thank you. Sorry, Chair Moeller. Commissioner Snell, of all these people that are in your facilities, are they separated from their families?
Commissioner Schnell.
Madam Chair, Chair Novotny, yes.
Chair Novotny.
Commissioner Snell, are the rest of the people that are in the facilities and all other facilities in the state that you either control or the county jails that you inspect, are they separated from their families?
Commissioner Schnell.
Madam Chair, Chair Novotny, yes.
Chair Novotny.
Thank you, Madam Chair. Commissioner Snell, your agency inspects the county jails, and one of the jails you inspect is the Sherburne County Jail. Has there ever been a fail of the ICE holding facilities at the Sherburne County Jail?
Commissioner Schnell.
Madam Chair and Chair Novotny, the answer is no.
Thank you, Commissioner Snell. Representative Hollins, my question for you is where? Where will these people on detainers be held that you would prefer that they be held? I see all the stuff going on at the Wiffle Building that I know admittedly little or nothing about, but where would you want them held? We've got the people that Commissioner Snell has testified to that have ICE detainers. Some of them, from testimonies that we had in last session, you might be familiar with, have committed horrendous crimes, murders. Sherburne County ICE facility was holding Zacharias Masari, I don't know if I'm saying his name right, one of the September 11th participants, before we even knew who he was or what was the plan. So where would you prefer that these people be held? You don't want them at the Whipple Building. You don't want them at local facilities that are controlled and inspected. Where would you like them held?
Representative Hollins.
Thank you, Madam Chair. Again, I think you're conflating the civil immigration aspects with the criminal aspects, but also I will defer to my testifier, who I think has a more thorough. answer.
Ms. Shaw.
Thank you, Chairman. I think there are two separate issues here. So one is the question of people held on ICE detainers, which are requests that a local law enforcement agency notify them if and when they're releasing the individual. And second, that detainer request says, can you hold on to the person for an additional 48 hours beyond when they would be released? So in the Department of Corrections context, if you've got an individual who has been serving a sentence, ICE is placing a detainer, asking for notification about that person's release. This bill does not prevent the Department of Corrections from providing that notification. In fact, Minnesota law already requires that, in fact, they do provide that notification with regard to an individual who is a non-citizen who committed a felony. So that's the detainer issue. With regard to the detention issue, so we're talking about civil immigration detention contracts, which are usually intergovernmental service agreements between some kind of municipal entity and ICE. And the question is, if you weren't I think your question, sir, is if you weren't holding people in one of, I think, 4 or 5 different local jails in the state that have those intergovernmental service agreements, where would they be held? So I think part of the answer to that, we can look to other states that likewise have banned these intergovernmental service agreements. And what we know from the experience of other states is that there's a concept that's, if you build it, they will come, right? If you build a jail, we'll fill the jail. And if you stop having those jail beds empty, you won't be enforcing against so many people. The other part of this is that if you are bringing those people into your local jail, they don't stay in that local jail. And if you look at the statistics for the Minnesota County jails, people are average length of time in a Minnesota County jail before you move on to another ICE detention facility, maybe 10 days, 12 days in some circumstances. So what's happening is that people are being put into a pipeline. They start in your local jail. They end up in ICE detention, which is deadly. 9 people have died just in this year alone. We all know this. Kids like Liam didn't stay in a Minnesota County jail. They were funneled into a detention facility for families in Texas, where there are reports of horrific conditions. So there's a moral principle here of our local taxpayer dollars and local taxpayer funded facilities going to help funnel people into deadly facilities in places like Texas and Louisiana. And then I think there's also just a empirical matter of if you close these facilities, would enforcement go down? And that has been the experience of other states that have had these bills. And of course, you wouldn't be alone in passing a bill like this. There are other states, I think the most close one nearby is Illinois, that have passed these laws.
Chair Navani.
Thank you, Chair Moeller. I guess I'm not going to I'm going to recommend a no vote on this, but I'd just like to say one thing. And our side of the aisle sits, and for the most part, we take it. Representative Pinto, I'm deeply offended by your implication that we haven't done anything, because you don't know. I will tell you that many members on this side of the aisle have made comments. We have talked. We have set up liaisons. We have tried to talk and set up communications between the federal and the local governments. We have tried that. We don't do it publicly. We do it backdoor. We try to be quiet and get something actually done. I'm not out looking for publicity. I'm not out looking for a clip to put on social media. With that, I recommend a no vote.
Closing remarks, Representative Hollins, briefly.
Thank you, Madam Chair. Thank you for the conversation. I would recommend a yes vote. Thanks.
Thank you for the member discussion and for all the testifiers. Representative Hollins renews the motion to recommend that House File 3413, as amended, be placed on the general register. Roll call has been requested.
Chair Moeller.
Aye.
Chair Moeller, aye. Chair Novotny.
No.
Chair Novotny, no. Vice Chair Feist.
Aye.
Vice Chair Feist, aye. Vice Chair Whitty.
No.
Vice Chair Whitty, no. Representative Berg.
Aye.
Representative Berg, aye. Representative Bliss.
No.
Representative Bliss, no. Representative Curran.
Aye.
Representative Curran, aye. Representative Duran.
Nope.
Representative Duran, no. Representative Engen. Representative Greenman.
Aye.
Representative Greenman, aye. Representative Harder.
No.
Representative Harder, no. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hudson.
Nope.
Representative Hudson, no. Representative Johnson.
Aye.
Representative Pinto.
Aye.
Representative Pinto, aye. Representative Ream.
Ream, aye.
Representative Ream, aye. Representative Rapinski.
No.
Representative Rapinski, no. Representative Schwartz.
No.
Representative Schwartz, no. Representative Steer.
No.
Representative Steer, no. Representative Tabke.
Aye.
Representative Tabke, aye. There are 10 ayes and 9 nays.
There being 10 ayes and 9 nays, the motion does not prevail. Members, we did have 2 other bills on the calendar, but we ran out of time. Again, appreciate all the discussion here, and with that, the meeting is adjourned.